So that's the beauty of a trust is it just goes about its business from the time you create it. People die, people are born, and the trust goes on. It marches on undisturbed by these events, making the proper administrative changes as people become incompetent, as they die, as successor beneficiaries come along. You can go on for generations, and you don't have to have generational quote-unquote wealth.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by TuckerAllen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today I want to talk in a little bit more detail about how trusts can be really useful, I would argue essential to your well-being as you age. As we diminish in our capabilities to be self-sufficient, as we face challenges and risks each day, that something could happen that could utterly disable us from managing our lives. This is one of the several critical things that estate planning using trust does for you. I really don't get the people who say, I've got a will, done, everything is taken care of. They're getting that advice from someone, and for a few of them it may be true if they have no assets to speak of, and I can imagine marginal scenarios where that might make sense. You save, several $100s, maybe $1,000 in estate planning costs, but in the scheme of things, does it make any sense? And I would say this incidentally, even if I weren't a lawyer. I'm not saying this because I am a lawyer, but I've said to my brother that he's in Kentucky. I can't practice law in Kentucky. When he is thinking of doing things to save money, for example, in estate planning, and when literally you're dealing with everything you own, everything, at least in a tangible form, is on the table that you've worked for your entire life. So whatever it is, whether it's a lot of money, whether it's not much money, whatever assets that comprise that thing, and some of them, incidentally, are heirlooms. Some of them are not so much about money. It's about the attachment and the significance of those items. But whatever there is in this world that you've accumulated is what we're talking about. We're talking about estate planning. So for some people, the subject is a little bit of a yawn because they figure that's not going to be relevant to me for a long, long time. If you're watching this show, that's probably not you, because we're assuming the people who watch this show, you're probably the last third of your life or so. And some people simply think that nothing's going to happen for a long time, though it could, meaning they are older, but they figure, I won't be one of those people who will have a stroke or a disabling physical event or a car accident, whatever form that it might come in. Often we don't recover when we're older the way we might otherwise recover. And of course, there are things that don't happen to young people that happen to older people in terms of health. So I think it behooves us to think about estate planning. I don't think it should be a boring topic. I think that in fact, it should be an interesting, even a very interesting topic, because you can do some cool stuff when you think about planning the last third of your life.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At TuckerAllen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on TuckerAllen, personalized estate planning made simple.
I talk about trust because I think that is one of the primary, one of the centerpieces, I would argue, of your estate plan is that you have this thing that you get to write the rules that govern it, and you get to choose the person that runs it. You will run it until you can't, until something disables you. You become quote unquote incapacitated is the legal term. And then the person that you've chosen takes over, and they take over and they run this enterprise being your life in all of its physical forms, dollars, stuff, financial assets, real estate, et cetera. So this person will not only be the person you chose, but it'll also be under a set of instructions that you created. You get to sit down now and create that set of instructions. To me, this is not a boring conversation. And I realize for some people, though, it is. So for them, they have to, it's this great exertion of discipline for them to go in and see a lawyer and get this done. Okay, so be it. If you're one of those people, but my argument is still you need to get it done. And there's so many cool, beneficial things you can do. So back to the topic about trust. I think trusts are probably going to be the center of that discussion. Not for everybody, as I suggested a few moments ago, but for the vast majority of you, it just makes sense. But it probably won't be just a trust. So when we talk about a trust, we're talking about this entity. It's technically a relationship in which you transfer assets to somebody who is the trustee. They accept ownership of them as a trustee, and they undertake an obligation to manage them on behalf of the beneficiary or beneficiaries that you've designated. Just as you can choose to have tiers of trustees, meaning one person who may be that active trustee now and something happens to them, whatever it may be, maybe they just resign, then you have a next tier and a next tier and a next tier so that you don't ever find yourself without a trustee. Similar thing with beneficiaries is you start out, if you're like most people, you'll say, we'll use an example. Let's assume that you're 66 years old. You're 66 years old and you're married and you're thinking, my wife and I, my husband and I, we need a trust. We need something in place that in the event that we can't manage our lives, we want some other means for it to be done according to our wishes. So you decide that a trust will be part of that plan. And when you make that decision, you don't necessarily put everything in the trust initially. You do decide, though, about the beneficiaries. And just like you want to start out being your own beneficiaries, you also want to allow for the possibility, though, that the time will come when the last of you will pass away. So as long as either of you is alive, you will be the sole beneficiary. But the time will come when the latter of you passes away. And then at that point, you have another tier of beneficiaries, whoever that might be. If you have children, it's probably children, but it could simultaneously or instead be your grandkids. That's a cool thing about a trust is you get to reach beyond your life and do good things for people that you care about that they can't do for themselves. This is much better than simply having a personal representative write checks in the distribution around a table a month or so after you pass away. And incidentally, it's more likely to be a year to 2 years after you pass away if you're doing this by way of a will. Not always, but wills, there's lots of opportunities for delays, administrative delays, conflict, people who choose to oppose the will, who challenge it, who argue that it's invalid, perhaps you were under duress, undue influence, fraud. There's so many bases, not to mention that there's lots of money that you lose along the way. There's kind of holes in the bucket between the time that you pass away and its contents get handed to the intended beneficiaries. And those buckets are consumed by court costs, attorney fees, or maybe somebody appointed by the court to decide certain things. That person, of course, gets paid by you. Personal representative is paid according to a statute in Missouri and most states, a statute that assigns a percentage of the estate to them. And they're allowed to charge more than that if they can show that they've used their time, that they've had to spend time accumulating, gathering your assets. Their job is to husband your resources in such a way that they protect it and allocate it to the proper people, creditors being first as a category, second are the beneficiaries. So they keep track of their time, and it's not unusual for the personal representative to, in fact, spend more than the statute provides. The statute says the minimum is the percentage. You can tell lawyers wrote this. The minimum is the percentage that's prescribed in the statute or that's listed, and the statute makes clear that if somebody has used more time, they can have more. And guess what? Turns out most do. The other thing is that if there's an attorney hired, a separate attorney, or maybe just a family member's a personal representative, whoever it is, they get paid according to the way I just described. Then, of course, you have the attorneys who charge at their own rates. They're not personal representative, but they're helping the personal representative. So there's lots of hands in this pie. And ultimately, by the time whatever's left is distributed after everyone's laid claims on it through the probate process, through creditors, et cetera, any challenges that might have been made to the validity of the will, et cetera. Ultimately, then it'll be distributed to whoever you had in your will. There is a better way, and the better way, of course, is to do this by way of a trust. So in this example where we're assuming that you're a married couple, you're age 66, you have beneficiaries, you have tiers of beneficiaries, you have yourselves listed. You want to be sure that as long as either of you is alive, even when you're incapacitated, that the person who takes over to be trustee while you're incapacitated will do it in a way that focuses on your care and your needs so long as you're alive. That's the way most people want it. Wouldn't have to have it that way, but I think most people want to have that set of priorities. Then when you pass away, then, of course, the trustee continues on. Guess what doesn't happen? You don't have a judge involved. You don't have a court involved. You don't have a personal representative involved. You have much less opportunity for challenging your trust. Is it possible that somebody can challenge it? Yeah, but for reasons that you can quickly understand, it's not nearly as common. And the reason is that a trust is something that you drafted and lived with for maybe decades. It's not like a will where you go into an office, you sign this piece of paper that maybe you weren't clear exactly what that piece of paper said. Or maybe that was a passing mood that you wouldn't have done if you had thought much about it, but you since haven't thought about it. And you did that act of signing those pieces of paper 10 years ago, 15 years ago, 20 years ago. That's not unusual. So you can see why wills are kind of set up potentially to be challenged. And you're gone. So maybe the person who could easily, the single person who we know could easily confirm whether there are these defects or whatnot, or there was this undue influence, is not here. So it's really an opportunity for those who might have ill will or ill intentions. It's really an invitation for them to come in and challenge. Contrast that to a trust. A trust is something that not that you signed and walked away and forgot about, but this is something that you live with every day to some extent. You don't have to be conscious of your trust every day. It's not management intensive by any means, but still it's something that was there. You knew it was there. You had to go to more trouble or at least require more attention in order to get it in place. But you can see when that is the scenario, it's not an invitation for someone to say that you were duped. It can happen, but it doesn't happen nearly as often. So another thing about trust is that they're confidential. Some people care about this, some don't. I like to mention it to clients because every now and then a client will lean forward and say, wow, so you mean that though wills disclose, we can all go down and look at the contents of anybody's will because it's probated and it's open to the public to see and read. And this person will lean forward and say, so you mean that I can create a plan that no one can look in and see the value of my assets, how I gave them out, et cetera? And for them, that will be the selling point. It's just confidentiality. So I mention it here because I know for some of you, that's a big deal. For me personally, it's not as big a deal, but I definitely get it. As a lawyer, certainly I understand privacy is a big deal in this age. Well, the good news is trusts give you privacy. But still, I think there are so many more powerful reasons. So when I'm talking to you today about how to have in place a plan that can take care of you the rest of your life, the centerpiece of that discussion will be and is a trust in the manner that I just described. Now, at the risk of this getting complicated for you, I've got to tell you that there are a few documents that go with it. And it's not a big deal, but some people just are a little impatient with much thought or attention to their estate planning. And for those of you, I ask you to bear with me. But in order to have a plan in place that is really kind of bulletproof and that takes care of you in the event that you're competent and capable till the day you die, or that takes care of you in the event that maybe you spend 2 decades, I hope not, but 2 decades where you're not competent, and somebody has to run your life in a way that takes care of your needs so long as you're alive, and not as an afterthought. So that person is hard to find, but that person you can create through proper planning. And it does require you identifying people, but the good news is If you do it correctly, if nothing else, you can have an institutional trustee to take care of you. In other words, to be the person who exercises judgment regarding your finances, at least. On a more personal level, you may want an additional person that is a family member who you know would have good intentions, though they may not have the same capabilities. So that's the reason often you'll see that the roles of trustee bifurcated between somebody who is going to be concentrated on management of your assets and then the other person who's going to focus primarily on the care of you more personally, your physical self, where you enjoy, what you enjoy, etc. And that team can be a powerful duo to manage the balance of your life. It really offers incredible peace of mind to be able to have something like that in place. So to do that, in addition to the trust, you do need what's called a durable power of attorney. We've talked about it a lot on this show, so I won't assume that you haven't heard of it. It is a simple document, though it's powerful, and it does require some careful considerations. There's a number of decisions to make that only you can decide for you how you want those things. There is no universally good answer as to many of these issues that have to be decided when you're creating a durable power of attorney. Among them is, for example, some people want the durable power of attorney to be in effect immediately, not because they want the person that they've named as they're called an attorney in fact. So get used to that phrase. It's attorney in fact. It does not mean, in fact, an attorney. So in other words, it's a confusing phrase, but that's the language that you'll hear associated with the durable power of attorney. Attorney in fact can be your sister. It can be your brother. It can be anybody, but it's just the person that you've chosen under a durable power of attorney to act for you. It could, in fact, be an attorney, but typically it's not. So it's called attorney in fact. You're the principal in terms of terminology here. So I've talked a little bit about this before. Matter of fact, you should find a show that I did in discussing a durable power of attorney. It's chapter 404 of the Missouri Code, but I think you'll find it if you go online and look at our past podcasts. It's been in the last couple months, but it has a lot of cool content. Durable power of attorney is the best thing going in terms of estate planning for your life as you age. Really, planning for your life as you age is a better way to say that. It doesn't focus on taking care of your stuff when you pass away. But in terms of the best deal around to very simply and cheaply, I mean, it's not very expensive to have a durable power of attorney. You want to have it done correctly, but it's not expensive to have that done. So a durable power of attorney is something that you can do without much cost. So continuing the example, so let's assume that among the issues that can come up is, do you want it to be in effect immediately? Some people do. Some people want to know that their attorney, in fact, can immediately start acting on their behalf if something happens. Others say, no. That makes me nervous that somebody has that degree of power and that they could choose to exercise it legally, meaning that there's not a trigger in the document that says, this will become valid upon such time in which there's a certification by 2 or 3 physicians, whatever you choose, often a couple of physicians that certify that Joe Blow is incompetent. So that means until such time that this person, the people that you've named as your attorney, in fact, they have no power until that time. But I think that creates kind of a burden. It's a hurdle that has to be gotten over in order for this to become active. There's nothing wrong with people who want to do that, but this is an example where there isn't a right or wrong answer, but that's an example of the number of intersections where a decision has to be made when you're doing a durable power of attorney. I generally suggest that, look, if you believe this person will take care of you when you're incompetent, then you can probably trust them to not abuse it when you are competent. And then just eliminate the requirement of getting certification from physicians that can slow things down. If you've chosen this person well, then don't worry that they're going to try to take over your finances while you're on a vacation or something. And if there is that concern, then you've chosen the wrong person. But anyway, there are some decisions like that have to be made with the durable power of attorney, but there aren't a ton of them. And this document, when you join it with the trust, then you're capturing most of the issues that are going to come up related to good estate planning. You've provided for your care for the balance of your life while you're alive. You've also done that with your trust. You've also, though, with your trust, taken wonderful care of what happens to your assets when you leave this world. Some of you are thinking, but wait, isn't this redundant? We said that the trust is capable of taking care of me while I'm alive. And then we just now created this durable power of attorney. Isn't there an overlap? Well, there can be an overlap, but not necessarily, meaning that, remember, the trust is going to govern, number one, only your assets. A durable power of attorney, you can give someone authority to do things beyond simply managing your assets. You can give them the authority to do things that are in the nature of health care. Though there is a separate statute, at the risk of confusing you, there's called a durable power of attorney for health care. But under the durable power of attorney for financial and legal matters, there is an option to make decisions about your care that you can choose in that document. It's not going to be as comprehensive as having the durable power of attorney for health care. So I would advocate that you definitely have that document created. Decide who you want making those decisions. It may or may not be the same people that you've chosen to make decisions relating to your durable power of attorney, which that is the broader, the more general power of attorney. And it could be the same person. It doesn't have to be. But I am simply pointing out to you that under the durable power of attorney, the general durable power of attorney, Section 404, that you have the right to give that person authority to make decisions about healthcare matters. Anyway, not a trustee. A trustee is not that person. If it was that person, then it's because you gave them also a durable power of attorney for healthcare or just a durable power with authority relating to healthcare matters. So the reason that you create this control, though, over assets in the durable power of attorney as well as in a trust in the event that you become incompetent is that most people do not transfer all of their assets to their trust. Now, remember when we described a while ago the trust, that you have this person that you've chosen who's going to kind of run things for you whenever you can't. You've set yourself up as trustee first, you and your wife, and then the survivor of you, probably, as long as you're competent, you'll be your own trustee. And guess what? You're also the beneficiaries. So that works out well. The only time that those two roles split up is while you're alive is if you become incompetent. And then when you become incompetent, you no longer want to be the trustee, and you want to be able to have that handed off to a successor, yet you want to continue being the beneficiary. So that's the beauty of the scheme as it relates to a trust. But you don't put all of your assets in this trust typically. And the reason you don't is usually related to tax concerns. The tax concerns are especially true with tax-deferred assets, retirement assets, 401ks, IRAs, et cetera. You have benefits associated with your ability to defer income until such time as you transfer those. You can transfer them in your life or you can transfer them at death, and both of those will trigger income taxes. But if it's handled correctly, you can spread that out. You can stretch it now. I think currently we can go 10 years. There's recently, I'm not a tax lawyer, but I do taxes, but I'm not a tax lawyer per se. So check this out. But the recent amendment, I think you can go out 10 years on a stretch. And a spouse still has the balance of her life, as I recall. So if you have a surviving spouse, you can stretch it out. But these are tax-deferred assets, and you want to take advantage of that, but it needs to go through your estate to do that. So if you go ahead and put, for example, your 401k, dump it into your revocable trust, then that does mean that you're going to trigger tax consequences immediately, and you're not going to get that stretch. Whatever's left of it will not extend a benefit of a stretch to your successor beneficiary. So it generally makes sense to use what's called a beneficiary clause, and these things make the asset immediately at your death go into the trust. They're not in it immediately. You can do this with almost every asset, can, believe it or not, be transferred by some form of beneficiary clause. Missouri passed a statute decade plus ago. It's called the Missouri Non-Probate Transfer Law. And a non-probate transfer is, in the statute, is designed specifically to deal with all those ways that you transfer things at death without their going through probate. And it's not intended to deal with trusts. Trusts have their own chapter in Missouri law, but this is entirely different. This is This is where you can have a beneficiary deed for real estate. You can have a beneficiary deed for it's not a beneficiary deed. It's transfer on death or payable on death. Applies to financial assets. Typically, if you have securities, it's going to be a transfer on death. Bank accounts were historically a payable on death. But you simply sign a form or fill out a form with various financial institutions or with the record of deeds, if we're talking about real estate, in which you can have a provision that that asset will go to a specific person or entity or something that would take effect immediately at your death and would not go through probate at all. So what happens legally is that instantaneously, the moment that you leave this world, that nanosecond, ownership passes. So it doesn't go into probate. It doesn't go into the hands of a personal representative who then files documents with a court, who then has hearings and other procedures to determine who creditors are, and after they're taken care of, who are the rightful beneficiaries. Is this deed valid? Was it properly executed? Blah, blah, blah. It bypasses all of that. But that really is the same thing. It's not the same thing as a trust, because with a trust, there is no transfer taking place as the assets that are inside it that are taking place at your death. That continues on undisturbed. So it's like you put things in this container called a trust, and the assets that you actually put in the trust are assets that went in at that time. Say you're 66 in the example we're using, then you put assets in there at that time. Well, when you pass, it's just an event. It has no effect on the continuation of the trust other than it would say, oh, we have now a new set of beneficiaries, so let's make an administrative notice that we no longer have you as a beneficiary. Now we have the grandchildren whose individual names would be mentioned, or children. So it's an administrative note and change. It's not a legal occurrence. It's not something that passes ownership at that time. So that's the beauty of a trust is it just goes about its business from the time you create it. People die, people are born, and the trust goes on. It marches on undisturbed by these events, making the proper administrative changes as people become incompetent, as they die, as successor beneficiaries come along. You can go on for generations, and you don't have to have generational quote-unquote wealth. You can have, several $1 million. I would think that you'd want to have a significant amount of money, but with not much money, you can reach into 2 or 3 or more generations. But with this example, I want you to catch the idea as to why would you not put everything in the trust. It sounds pretty clean, doesn't it? You put it in the trust, and the trust goes on and just goes on down the track, and it passes stations and makes its notes and makes its transitions of trustees and beneficiaries, and on it goes. That is the preferred thing, and as I suggested a few moments ago, there are sometimes reasons that you don't do it, and typically they do relate to taxes, and IRAs are a good example, probably the best example. I should say more generally, tax-deferred assets are really the best example, but there could be others. So it's harmless in a way that the transfer into the trust doesn't take effect until the moment you pass away. There's no harm done by that as long as you have, in addition to a trustee managing what's inside the trust, you have someone else, often the same person, managing stuff that is not in the trust. And you can see the logic for having the same person do both. I mean, since they're managing the same pot of money, you kind of want it managed according to the same rules in all likelihood, in which case it's really almost imperative that you have the same perspective and judgment as to things that are in the trust and things that are outside the trust. So just to be clear, so the way that those things that are outside the trust that you deliberately did not immediately put in the trust when you created it, you provided for that management through the durable power of attorney. But then you created a beneficiary designation in which those assets will get transferred into the trust at the moment you pass away. So you bypass all the things I was describing about what goes on in probate. It's not always, incidentally, as dreadful as we tend to make it, but it often is. And to some extent, it always has some of the characteristics that I described to you. It doesn't always mean that there's an ugly fight, but it does mean delay and expense. You know that. So you get to bypass that. So that's the reason that, yes, you do need a durable power of attorney because you want to manage those assets that you haven't put immediately in your trust. Just to be clear, everything eventually will go into your trust. You don't want to go on for generations with some things in your trust and some things floating around outside it. Generally speaking, you want to have a single plan in place. It's just that those pieces that for their own peculiar reasons you're not transferring into the trust immediately, those things will get integrated into that single vehicle, the single vehicle that will manage all of your assets that you have for perhaps generations will be the trust. So the trust is the center of action. I don't want you to view it as simply an ancillary tool or one among many. Ultimately, we want your assets acting under the same plan, in the same place, the same rules, the same set of or individual of leaders. And your trustee can be one person. It can be two or three or more acting simultaneously. You can see the problems with as that grows. So you want to choose carefully when you have multiple trustees to not invite conflicts, and probably want an odd number. But my point is, you want everything to be managed according to a single plan. But recognize that for some of you, it will not make sense to move everything immediately into your trust. But the good news is there's no cost associated with having it, no delay associated with having it transferred by a beneficiary clause. The Missouri non-probate transfer law is very effective in protecting things that, whether it's all those assets I named and more. I mean, there are assets, I guess, that you can't transfer that way, but if you think about it, there's not a lot left. You can transfer real estate that way. You can do it with financial securities, with brokerage funds. You can do it with bank accounts. So for most of you, and incidentally, you can do it for things that don't have documents of title. And that's stuff like your furniture and tangible property, an art collection, for example. It is possible. Now, those things, incidentally, you won't do by way of some sort of beneficiary clause. Those are the things that you'll accomplish without probate, but those are more likely the things that you will put in the trust. So let me clarify that. You wouldn't do that outside the trust. But that's what one of the many great things about a trust is you can prepare a document of gift that says, I hereby convey all of my tangible property at such and such property, such and such address into my trust. And it's done. It's done. And even as stuff come and go, you don't have to change that transfer. It's happening in the context of the trust. So there are some I's to dot and T's to cross whenever you have a revocable trust and you would be acting as trustee. I mean, there are a few things, but I don't want you to think that it's this administrative burden, that there's a lot of hassle. Really, the hassle is on the front end, and that's just creating it. And it's not much hassle. It's more that it costs you a little more than a will would. But it's just you can't even talk about the differences and suggest that they're anything comparable. You get so much more done with a trust, and I think I've conveyed that in this conversation. Perhaps you came to this conversation knowing that. I hope you did. Trusts are powerful, powerful tools. They're not just for rich people by any means. It's true you could own very, very little in this world, and perhaps maybe you want to go get a form will and go on your way. I'm willing to bet that for 95% of you, what you have accumulated in this world is significant enough, and you care enough that you want to be sure and be the good custodian of it that you should be. So I've mentioned the durable power of attorney. I've talked about trust, how these things need to work hand in hand. They should go together. I can't wrap up without mentioning a will. Having said all those things to disapprove of will as the centerpiece of your estate planning, there is a function for a thing called a pour-over will. If you've watched this show very much, you know about this, but I just, in terms of due diligence, I want to be sure I mention it. So if you're thinking about what are the key components to an estate plan and to a balance of life plan, if you're 60 or so and beyond, I would argue that you need the trust. The trust is going to be the centerpiece of your future and the future of those you care about. The durable power of attorney, though, may be a place that will control some of the assets until the moment that you pass. So you want to be sure that you create both documents so that you can still have them both operating according to the same plan, even though some of those assets, for the reasons that I explained, are going to be outside the trust until the moment that you pass away. They do not go into probate. I hope I've said that enough. They don't go into probate, but they are kept outside the trust just for the balance of your life. The other piece that I mentioned, the will, the pour-over will, that third document, is really, imagine that a person who's on a high wire, does it make sense for them to have a net below them? I think we would all agree, yes. Certainly if we were the one on the high wire, we would say that's a very good idea. So that's kind of what a pour-over will is. We don't want anything to go through your estate, to go through probate for all the reasons we've talked about. But oddly enough, you want to have something there in the event there's something that, gee, I didn't know was there. I didn't know I owned this asset. Or I thought this asset was transferred and it wasn't. We hope that doesn't happen, incidentally. But the point is, there could even be assets that you had earned and were entitled to that no one knew about, including you, until the moment you passed. Undiscovered assets. There could even be things that arrive new to your ownership in the last phases of your life that you had no. Maybe you were included in a class action suit, and maybe it settled weeks before you passed away. So it doesn't take a lot of imagination to think, oh, yeah, there could be something that we don't have it with the beneficiary designation going into, controlled by the durable power of attorney, and we don't have it in our trust. Oh my gosh, what happens to it in that case? Well, as you might suspect, it would go in, it would be set for the state to decide how it would be distributed, because there would be no plan, nothing to catch it, no net below. So that's all that whenever people talk about a pour-over will, as the name implies, ideally nothing will go into your probate estate, hopefully. According to the ideal plan, nothing will. But do you want to risk there being something that you didn't know about when all you had to do is create this thing called a pour-over will that simply says, oh, incidentally, probate court, if there is anything in my estate, I want you to put it inside my trust. That's really effectively all that the pour-over will does, is it takes anything that lands in your estate and it dumps it into your trust, whereupon those things are managed according to the same rules that everything else is. So you can see how these three items come together to sort of give you a lot of peace of mind about your personal care for the balance of your life, but maybe more importantly to you, and I suspect more importantly, is caring for those that you care most about, some of whom you may not met and may never meet. Maybe a generation, maybe grandkids that might come along after you've gone, or their kids. That's a really cool thing about using trust, is there is no deadline on your ability to be helpful to people in your future. There may be financial limitations, and I understand that, but those limitations are not as high, and the bar is not as high as you think it is, many of you think it is, in order to be helpful to those you care about beyond simply the next generation. So I suggest you think about that. If you're doing a trust, you're doing this plan, probably won't cost you any more money. I mean, whatever you're paying, most attorneys will not charge you more to have those provisions. So why not go ahead and think big? Think, what if I had an incredible rate of return on this money for the balance of my life? What if there's some source of funds that could end up being more than I think it's going to be? What if I passed away tomorrow and there's more assets? I didn't use any of the assets that I had available. And maybe your grandkids are 2 and 3 or 4 or 5 years old, and that money would sit and accumulate, and it would compound for 20 years or 30 or 40. Even for your adult children, they may not be able to best use that until their retirement. That's an idea. So the point is, you could be talking about far more money than you think you are. And I'm suggesting when you do your estate planning, be ambitious. Be ambitious for the people that you care about and for the balance of your own life. So this has been another episode of Life's Third Act. Till next time, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by TuckerAllen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit TuckerAllen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.